I was reading a Supreme Court judgment and I noticed that the Honorable Apex Court described the importance of pleadings and also went through the lines of the plaint which were filed before the trial court in order to ascertain as to whether the non est factum, the elements of non est factum was available, since the case of the plaintiff was on a footing which according to law may not be called which according to common perception may not be called a very strong footing. Case of the plaintiff was that he had executed a power of attorney with an intention to divide the land into smaller plots and to obtain necessary permission from the authorities. And in the power of attorney, the plaintiff had never authorized the defendant to create, to sell, to create mortgage, or to execute gift deed, etc. etc. The suit was dismissed, but the appellate court noticed that the element of non est factum was fully established, allowed the appeal. However, the Honorable High Court reversed the finding on the ground that defendant pleaded that there was no suit by the plaintiff for cancellation of the power of attorney or for cancellation of the sale deed. The High Court was swayed away by this contention. However, the Supreme Court upheld the trial court finding. The point is that it appears at first blush that a very strong plea was raised by the defendant to this effect that there was no litigation or suit instituted by the plaintiff for cancellation of the sale deed or for cancellation of the power of attorney, and therefore they had no case. The apex court went to the extent that once the document is found void, then such sale deed or power of attorney has to be ignored, and there was no need of instituting any suit for cancellation of them, which means not filing of the suit for cancellation of the power of attorney and the sale deed by the plaintiff, would not defeat the purpose of filing the suit by the plaintiff. On the ground that the power of attorney was not meant to execute sale deed or transfer the property, but it was meant only for dividing the land into smaller plots and obtain necessary permission from the authorities, because the defendants had good liaison with the authorities. The Honorable Apex Court went through the pleadings of the plaintiff and noted that in the plaint there was a specific averment that intention for executing the power of attorney in favor of the defendant was for developing the property in question into smaller plots and get necessary approvals for the same from the relevant authorities. It was also pleaded that the plaintiffs were illiterate and had no means to get the above exercise carried out, and as the defendant was well versed in the dealing with government authorities, he could have helped them in developing the plots. It was also mentioned in the plaint that plaintiffs realized that the defendant had two additional clauses incorporated authorizing him to sell, gift, settle the plots in question. This was never the intention. These two additional rights recorded in the power of attorney was never intended, nor conveyed, nor informed. It was also mentioned that taking advantage of the illiteracy and simplicity of the plaintiffs, such clauses were incorporated in the power of attorney. Thus, power of attorney was not in dispute. The question is that by reading this paragraph, it is apparent that how important becomes the pleading in the plaint. And we as a lawyer must mention all the expressions and explanation of the client in legal terminology in the plaint, which is a basic document. Not only that, as an advocate, whenever a civil case comes, the lawyer is expected to go through the plaint and written statement word by word, irrespective of the fact that plaint and written statement have been, and other documents including evidence have been thoroughly analyzed and finding recorded by the trial court. That itself is not sufficient, since for preparing a case in the High Court or in Supreme Court, it is incumbent upon the lawyer to not only read the judgments but also read the pleadings mentioned in the plaint and the written statement, because the entire case is made out upon that. I'm going further. The Supreme Court had also added that the plea of non est factum could not be available to anyone who signed without taking the trouble to find out at least the general effect of the document, which means a person has to exercise a reasonable efforts to read the document or to understand the document and contents with the help of some knowledgeable person. The Supreme Court further submitted that any carelessness and mistake on the part of the plaintiff would not entitle him to claim the benefit of the maxim non est factum. Supreme Court categorically observed that the defendant respondent had taken a plea before the High Court, and which was given due consideration by the High Court also, that the plaintiff appellant had not sought any relief either for declaration of the power of attorney as void, as also the cancellation of the sale deeds. Apex Court said that law is well settled that where it is alleged that the document of sale is void, then no cancellation would be required and such document can be ignored under law. Cancellation of a sale deed would be necessary only where it is alleged to be voidable on facts. The Apex Court emphasized the importance of pleading, saying that the object and purpose of pleadings and issues is to ensure that the litigants come to trial with all issues clearly defined and to prevent cases being expanded or grounds being shifted during trial. The object is also to ensure that each side is fully alive to the questions that are likely to be raised or considered so that they may have an opportunity of placing the relevant evidence appropriate to the issues before the court for its consideration. Pleadings are meant to give to each side intimation of case of the other so that it may be appropriately met to enable courts to determine what is really at issue between the parties and to prevent any deviation from the course which litigation on particular causes must take. The observation of the Honorable Apex Court regarding importance of the pleadings is not confined to the pleadings before the trial court, but before the High Court also under Article 226 of the Constitution of India. So every writ petition having original jurisdiction or invoking original jurisdiction of the Honorable High Court must be carefully drafted, and all the facts relevant for adjudication must be brought into it. The case I am reading becomes important also because the Apex Court, while deciding the issue, went to the extent of examining the conduct of the attorney, saying that on the same date of execution of power of attorney, the attorney holder executed two sale deeds, that is, transferred the property, one in favor of his father and another in favor of his brother. And the defendant failed to explain his conduct as to why he was in such a haste to transfer the property on the same date to his own father and brother. Secondly, the conduct was beyond explanation since the property was worth rupees 3 lakhs at that relevant time but was sold for 12,000 rupees to each person, and stamp duty was also not paid, hoping that in case the suit of the plaintiff fails, then the stamp duty would be paid, and the same happened. Once the suit was dismissed, the stamp duty was paid as per the market value. Since the deed were impounded by the registering authority due to deficiency of these stamps. So in essence, the submission and the inference is that pleadings very important at trial stage as well as at High Court while drafting a writ petition. Secondly, benefit of non est factum is available. Non est factum, I repeat that this is not my deed, which means the document was, although signed, the document is not disputed, but the contents of the documents were not intended or fraudulently incorporated without the knowledge of the executant, either because of his illiteracy, because of his illness, because of his inability to understand the legal terminology, etc. Although it is another factor that the plaintiff has to prove, but so far as the pleading is important, the proper averments should be mentioned, explaining each and every step, so that the at subsequent stage the benefit of non est factum could be availed and could be effectively proved before the court also.